All right, we'll go ahead and call the third case. Lifecare Centers of America versus the estate of Ruth Ann GREEDAN. Counsel, did you need any more than 5 minutes?
No, Your Honor, 5 minutes will be fine. May it please the Court, my name is Michael DeLugo from the law firm of Wicker Smith in Orlando, and I'm here on behalf of Lifecare Center of Ocala, and I'm here to request that this Court reverse the trial court's granting of the plaintiffs below motion for new trial. The sole issue that was raised in the motion for new trial was the trial judge's decision not to give a concurring cause jury instruction. We would submit on behalf of Lifecare that based upon the facts, that in this case, that a concurring cause jury instruction was not warranted because there was no concurring cause included in the evidence.
Let me ask you along those lines about the following questions that were asked during the course of the trial. Counsel for your client asks this. If there were things about her general medical condition related to her lungs, her COPD, her heart, her weight, those types of things that more likely than not, within a reasonable medical probability, affected her ability to have a chance to recover from a perforation if one was going to happen. Now, you would acknowledge I'm quoting that correctly?
Yes, Your Honor.
Okay, so why doesn't that line of questioning in and of itself give rise to a concurring cause instruction?
So the issue that was raised with regard to Ms. GREEDAN's other medical conditions other than the perforation were designed to create a record for the jury to consider with regard to her damages, that her life expectancy was poor going into this whole procedure.
Now, this goes to her ability to have a chance to recover from a perforation. That's not a question about life expectancy necessarily. I mean, it might impact life expectancy as well, but it certainly seems to cover causation.
It does, and the question's there, and the record is what the record is.
Yes, that's right.
And I'm not here to contest. I mean, that is an accurate statement of the record, but our position is that the presentation of both sides, both the expert of Dr. Locatel on behalf of the plaintiff and the two experts that Lifecare called, all agreed that this was the perforation caused her death, and that once her bowel perforated, that she was going to die. There was nothing that could be done because of the nature of the perforation. It was, in fact, our surgical expert who testified that based upon the severity of the perforation, that there was nothing that could be done once the perforation occurred.
Although it wasn't a focus of the trial, her certificate of death was in the record, correct?
That is correct.
And the certificate of death actually lists 3 causes of death, correct?
That is correct.
Okay. How is that alone not enough to get a concurring cause instruction?
Well, the issue is, and I want to address this court's Hadley decision because I think this is something that the court needs to address. And the issue is whether or not this is a concurring cause, whether the bowel perforation was a concurring cause. And you have to look at it in the context of what could have been done prior to the perforation occurring. And what the plaintiff's argument was is that if the nurses at our facility had done a proper job in monitoring the patient and had notified physicians of a change in condition, that the doctors would have gotten involved and would have ordered antibiotics, that the antibiotics would have reversed the course of the diverticulitis, and that this never would have occurred. Under those circumstances, given the facts of this case, under Hadley, under the majority in Hadley, that the concurring cause instruction needed to have been given. I would submit that Hadley was wrongly decided. It is contrary to the Supreme Court's decision in Goldschmidt, and I think that Judge Monaco's dissenting opinion is something that this court should address, should review, and I think that the facts of this case fit squarely under Goldschmidt and fit squarely within Judge Monaco's dissent in Hadley.
But without a concurring cause instruction, the jury could have just as easily found that her diverticulitis and other medical issues caused her death instead of the defendant's negligence, correct?
Yes. And believe me, as appellate counsel, I wish that the concurring cause instruction had been given. We wouldn't even be here. But it wasn't, and I think that the trial judge was correct in not giving it. And I think it's also instructive to look at the transcript of the charge conference, because this issue obviously was addressed squarely by counsel for both parties and by the trial judge during the course of the charge conference. And the trial judge said, I didn't hear any evidence of any other concurring cause. Everybody agrees that this was a bowel perforation that caused her death.
Well, he didn't say exactly that, because here's where I think a lot of the confusion came. The court's exact quote was that he didn't hear somebody else was to blame, but it's not just somebody, it's something else, correct?
That is correct.
Okay.
And I would submit that it is not the law, or it should not be the law, that there is a per se rule that if there is a failure to diagnose, you automatically get a concurring cause instruction. And that's what this case in effect is. I mean, it's not a failure to diagnose precisely because my client is a nursing home and they're not charged with diagnosing diseases, but they're charged with reporting out on changes in conditions so that a doctor can make that diagnosis. But in effect, what we have here is a failure to provide Ms. GREEDAN with the remedy that she needed according to the plaintiff's theory. And under Goldschmidt, if you have a situation in which a patient has a condition that can be adequately addressed and reversed, then that is not, as a matter of law, a concurring cause. In Goldschmidt, the issue was a failure to diagnose appendicitis. And the testimony was, if the proper diagnosis had been made, then the appendectomy would have been performed and the patient would have gone home in a couple of days and she would have been fine. Well, that's essentially what, and the Supreme Court in Goldschmidt concluded that under those facts, a concurring cause jury instruction was not required. Well, this is essentially the same thing. What the plaintiff's theory is that our nurses should have reported out on Ms. GREEDAN's condition. Had she done so, or had the nurses done so, Ms. GREEDAN would have been provided antibiotics. Those antibiotics would have reversed the course of the diverticulitis, and the bowel perforation never would have occurred, and she would have gone home fine. So that's not a concurring cause, and I think that Judge Monaco's dissent in Hadley gives an excellent explanation of that. And so I would request that this court go back and look at that Hadley decision and reach the conclusion that, in fact, it is contrary to the Supreme Court's Goldschmidt decision, and therefore there should be a reversal of this case with instructions to enter a final judgment in favor of LifeCare. The second issue that we have raised in our initial brief is that the trial court should have granted our motion for directed verdict, and the basis for that is that there is no competent evidence in the record to demonstrate that there was anything that LifeCare either failed to do or did do that was causally related to Ms. GREEDAN's death. And the basis for that is the only expert that the plaintiffs called below was Dr. Locatel. Dr. Locatel's conclusion or opinion was based upon a series of inferences, and you cannot reach a final opinion on causation based merely on a series of inferences. Yes, she did review the record, but the fact that reviewing the record thoroughly is not, and stacking inferences are not mutually exclusive. And so what Dr. Locatel did was she said if the nurses had done their job, according to her, and noticed a change in condition in Ms. GREEDAN in the 4 to 5 day period before her bowel perforated, then they would have notified the physicians of that change in condition. If the doctors had received that information, the doctors would have ordered antibiotics. If the doctors had ordered antibiotics, they would have worked and they would have reversed the course of the diverticulitis. If that had occurred, then the bowel perforation would not have occurred. And if the bowel perforation doesn't occur, then Ms. Greedon leaves our facility fully healthy.
But if your client doesn't do anything, aren't they left to stack those inferences? Because she was a 10 out of 10 on the pain scale. She hadn't had a bowel movement in 4 days, and they didn't refer that to the physician. I mean, how else can one prove causation when the nurses at your facility didn't take any action on it?
They made the decision that that was not a change in condition that was worthy of being reported. So
that's a jury question, right?
we would submit that the opinion of Dr. Locatel was not competent because of inference stacking. It's always a difficult argument to make in a negligence case, and I'm not trying to sugarcoat that fact, but we would argue that the trial court should have directed a verdict in favor of Lifecare.
I want to go back and discuss Goldschmidt a little bit. In the opinion of Goldschmidt, they say at all times Goldschmidt defended on the ground that he was not negligent. No one argued or presented evidence that any other operative cause was present. Now, do you think that's the situation in this present case?
True that we took the position that Lifecare was not negligent. Lifecare's position during the course of trial was that this bowel perforation was something that was not foreseeable, it was not diagnosable, it was not preventable, that it occurred in a window approximately 6 hours before she presented to, or she was transferred to a hospital. So we're talking about approximately from 9 p.m. on April the 29th of 2016 to 3 a.m. on April the 30th of 2016.
But it just seems to me that the introduction of evidence as to her COPD and other issues, distinguishes Goldschmidt.
And it is different in the sense that there is testimony with regard to COPD, with regard to a heart condition, with regard to a kidney problem. But again, as I referenced before, that testimony was in the context of her life expectancy as an effort to diminish damages if the jury were to find that there was negligence on the part of Lifecare.
Right. But I'm not so sure it's that simple to say, well, it only goes to this, it doesn't go to this other issue when really it's arguable that it goes to both. So
Understood.
Right. Okay.
And with that, unless the panel has any further questions, I would like to reserve the rest of my time for rebuttal. Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
Tom Harmon, on behalf of the estate of Ms. Greedon, appellee. Your Honor, prior counsel, you asked him, what was your best case? And I heard you say that. I'm just going to go straight to my best case is Hadley. Hadley was the failure to diagnose a child's advancing meningitis. I would submit directly on point with this case. My second best case is the 4th DC opinion in Austere. Austere is a failed to timely diagnose advancing breast cancer. In both the Hadley decision and Austere, the arguments, the defense were pre-existing conditions, that the child had some pre-existing conditions, that, and it was a natural progression. In any breast cancer case, the natural progression of breast cancer is ultimately death if there's not an intervention. And if it's a negligent intervention, there is your concurring cause. And as this court pointed out, the danger. And in the Hadley decision, this court articulated the danger of not giving the concurring cause instruction is that the jury will, quote, be confused, quote, about the necessity of finding defendant's negligence was the sole cause pursuant to the but-for instruction given to the jury of the injuries suffered by the child. And as Your Honor pointed out, and I would submit, especially in a nursing home case, you can never win a nursing home case without a concurring cause instruction, because in every single nursing home case, we have multiple pre-existing conditions. Nursing home residents come in the facility with COPD. They come in with other conditions. Ms. Greedon came into this facility with diverticulitis. They knew it. And then over the course of, and I will judge, I brought this was just a demonstrative exhibit that we used at trial. And over the course of especially the last 4 days, Miss Greedon began to exhibit the classic signs and symptoms of diverticulitis. And we didn't argue about the definition of is, but what the focus of the trial was the definition of a significant change in condition. And we argued, and Dr. Locatell stated unequivocally, that she was showing the standard signs and symptoms of diverticulitis, 10 out of 10 pain, nausea, not eating, hadn't had a bowel movement in multiple days, and the nursing home negligently failed to notice that, negligently failed to intervene.
We do record these, so if we could get you back in front of that microphone.
Negligently failed to intervene, just like Hadley, negligently failed to intervene, just like Austere. And in closing argument, without the concurring cause instruction, the argument was made, look at the death certificate. How could the nursing home be the but-for cause of Miss Greedon's death when we have at least 2 causes on the death certificate that had nothing to do with the nursing home? I believe there was hypertensive heart failure on the death certificate. The nursing home had nothing to do with that. And there was another cause. There was 3 lists on there. And that jury can go back and go, well, how can we say but for this negligence that the nursing home was responsible? So that's the danger. And so I would submit that as this court articulated in Hadley, that meningitis case is, quote, the classic concurring cause case. This is the classic concurring cause case because of all the pre-existing conditions, and that, be that meningitis, be that cancer, or in this case diverticulitis, it will ultimately cause the death of the patient if intervention is not taken. And that's exactly what happened, and we argued in this case. We did argue over whether it was or was not a spontaneous perforation. Dr. Locatell disputed that it was a spontaneous perforation, but rather a classic perforation given the signs and symptoms. I'm going to go and then...
Even if it was a spontaneous perforation, wasn't the defense's argument that once a perforation occurred, because of her medical condition, she couldn't have gone into surgery or couldn't have withstood surgery?
Yes, sir. Absolutely. That given her advanced age and weak condition, that unlike you or I, she didn't have the strength to recover from a surgery of that magnitude. And so it was her pre-existing conditions that made her not a candidate for surgery. I would, Your Honors, just 3 cases. The La Petite Academy case that was cited by defense counsel in our brief at page 18. We distinguish it. I would respectfully submit La Petite, that case is misplaced here because the request for the concurring cause instruction discussed in La Petite was, quote, the nature of children. And I think the court said that's more of an artful way of arguing for comparative negligence, and that the nature of children is not a pre-existing condition like meningitis or diverticulitis, and that there was no evidence at trial argued by either side that Ms. Greedon was in any way negligent and did anything comparatively negligent or contributorily negligent. The other case is Gooding. We distinguish that at page 23. The Gooding decision is the inference stacking cases that the counsel cites. The court pointed out, and I quote in Gooding, plaintiff's expert, quote, failed to testify the immediate diagnosis and surgery more likely than not would have enabled Ms. Gooding to survive. We distinguish that. Dr. Locatell unequivocally stated that if the nursing home had properly intervened, contacted the physician, antibiotics could have gotten ordered and she would still be alive today. So we met the standard in Gooding, and that's distinguishable. The last case, Siegel, page 24 of our brief, we tried to distinguish that. The Siegel decision was an advancing pneumonia case. The difference is in Siegel, you had a complete gap in the records. And the expert came in from the plaintiff and said, well, I believe he or she had advancing pneumonia, but the problem is the diagnostic tests, the examinations, all were contrary to that, and plaintiff's experts even admitted that the diagnostic test didn't support pneumonia. So it was an inference that the patient had pneumonia without any record evidence or diagnostic tests. We don't have a gap of records in this case. We don't have a lack of evidence. In fact, that's why I brought this exhibit. All of the records supported the diagnosis of diverticulitis. And in fact, she had diverticulitis. And there's no dispute as to that. So as for Siegel, again, that case is misplaced because I agree. An expert can't come in with no record evidence, no diagnostic test, and offer a diagnosis that's not supported by the records. The diagnosis of diverticulitis is supported by these records. So With that, I'm going to listen to my instincts and shut up and ask the court, I guess the burden is to show that the trial court abused his discretion in granting the new trial. The court cited Hadley, and I respectfully submit that the trial court properly cited Hadley and that his decision should be affirmed. Thank you.
Thank you.
Judge Monaco, in his dissenting opinion in Hadley, called the issue of issuing a concurring cause jury instruction in a failure to diagnose case, quote, muddy, close quote. And I think that what Ms. GREEDAN or the estate is advocating here is that there should be a bright line test that in every failure to diagnose a medical condition case, there necessarily has to be a concurring cause jury instruction because you've got the underlying condition and the failure to diagnose, and that those are concurring causes. And I think that that is directly contrary to the Supreme Court's opinion in Goldschmidt. There are certain types of cases in which a failure to diagnose a medical condition, it does not constitute a concurring cause, and this is one of those cases.
Well, as Judge Cohen pointed out, though, it wasn't just the pre-existing condition that was brought up, correct? As
Right,
a potential issue.
that is true. However, I want to emphasize that these other medical conditions that Ms. GREEDAN has, and Mr. Harmon is correct, there is no such thing as a nursing home case in which you don't have a pre-existing condition. It's just the way, the nature of the business in which my client operates. However, in the context of this case, I would submit that the testimony with regard to her heart condition, with regard to her lung condition, with regard to her kidney condition, those were all of that was evidence of her life expectancy, which was designed to impress upon the jury that if there were a finding of negligence on the part of LifeCare, that the damages would be reduced in light of those conditions.
Did counsel for the nursing home argue the death certificate on closing argument?
I believe so. I'm trying to recall, and I apologize. I don't want to misrepresent the record. I believe so.
Well, if they did argue that, as Judge Cohen said, and argue the three things were on there, isn't that precisely a concurring cause issue?
Again, it was intended, from my perspective, it was intended as an argument to impress upon the jury that any sort of damages award would be lowered in light of her other conditions, not that her cause of death was the heart condition, the kidney condition, the lung condition.
But the certificate of death, and I'm reading it here, the third cause is hypertensive heart disease under the heading of cause of death and injury information. I understand what you're saying. The argument of counsel in the closing argument can be framed as a life expectancy and damages issue, but I mean, hypertensive heart disease is listed as a cause of death.
Understood, and I can't hide from that. The record is what the record is.
Well, why would that, it was admitted for some purpose, and you're suggesting that in your position, the argument, the reason it was admitted into evidence was to demonstrate life expectancy?
That's correct, Your Honor.
All right, okay.
And with that, if there are no further questions, I will return to my seat. If the panel may indulge me for just a moment, I have brought some visitors with me today.
Sure.
I just want to stand up.
And who have we got?
We've got 4 law clerks who are serving as summer associates at Wickersmith this summer.
Wonderful.
We have Jasmine De Leon
Count 5.
from FAMU,
Okay.
William Ford from the University of Florida.
Aye.
Nicole Rothman is an undergraduate at Florida State University. She is also my niece, so wanted to give her a shout. Adam Wicker from the University of Alabama. And in the back, Michelle Mulvane from the University of Florida.
Wonderful.
Wicker is
Welcome.
in the Wicker?
No, actually, I have to keep on introducing them as no relation. So Adam Wicker and William Ford are not relations to Wicker or Ford in my firm.
Well, welcome. I hope that you enjoyed the arguments. We had some great lawyering, and I think you were lucky to come today because all 3 cases had excellent presentations and very good lawyers, and so you got a chance, with these lawyers included in that, I've known Mr. Lugo for many years. You've got a chance to see some interesting cases and some good lawyering done today.
Wonderful.
So welcome.
So thank you for coming.
Good luck as you go forward.
Thank you.
Now, some